Jonathan Pollard, Florida employment lawyer. I'm going to talk today about age discrimination. Folks, in the American workforce, age discrimination has become rampant, and it is only going to grow and become an increasing problem over the next 5 to 10 years. Folks are living longer, they're working longer, there are more employees staying in the workforce well into their 60s and even their 70s. And so in connection with all of this, age discrimination is going to become an increasing problem in American society, and it's going to also become an increasingly litigated area of law. There's already plenty of age discrimination litigation, but there's going to be a massive uptick in this particular litigation space over the next 5 to 10 years. So let me tell you what I see from my vantage point. We get hundreds of leads, inquiries, phone calls every single week. So I have literally seen thousands of case inquiries, intake forms, case synopses, etc. And when it comes to age discrimination, the first thing that I want people to recognize is that age discrimination impacts women far worse than it impacts men. That doesn't mean that there's not age discrimination against men. Absolutely there is. But there is a gender difference that you need to understand, that you need to recognize. From my vantage point, when it comes to men, I rarely see an actual, viable, strong case of age discrimination involving a man who is less than 50, almost never less than 50, and very rarely less than 55. Now, with women, it's extremely different. I have seen plenty of strong, viable, real age discrimination cases involving women who are 45 plus. So as I see it from the data that I see, the analytics, age discrimination really starts hitting women almost a full decade earlier than it starts hitting men. And will there be outliers? Will there be, one-off cases here or there where you can sort of counter that trend? Of course, right? Like you might be a 47-year-old man and have been discriminated against. You might have a case, but that doesn't change the overall trend, the overall big picture that women, my experience from the past 10 plus years of doing employment law at a high level and at a significant volume, women bear the brunt of age discrimination, and it starts impacting them in their careers about a full decade earlier than it does with men. So with that said, recognizing that it's an issue and recognizing when it starts hitting men versus women, really with women, 45, give or take, and with men, more like 55, let's talk about what we are looking for in terms of case selection and sort of how these cases play out, okay? There will be cases involving the proverbial smoking gun. There will be cases where a decision maker, a manager, a supervisor says point blank, you're too old. We want to get some hot young talent in here. That comes from the actual case files. I had a case involving a large retail chain, and they actually terminated a manager who had a very successful track record as a manager at one of these stores' locations. They terminated her on the heels of new regional leadership making it clear that they wanted to get some hot young talent in the door and sort of get rid of older folks, and especially older women. So you will have cases like that involve the proverbial smoking gun. Anything that goes in that direction, anything where somebody says, we want younger blood, we need more energy in here, you're too old, you're too slow, it's time for you to retire. We have that case as well, we've had a number of cases that involve the powers that be going to a successful, long-standing employee who has positive performance reviews, documented history of doing a good job, and tells the person, it's time for you to retire, out of the blue. And we're not talking about a job that, requires certain demanding and exacting physical performance where you could realistically have an age limitation there where you would need to have medical tests or periodic physical evaluation, etc. We're not talking about that. We're talking about a job that the person did well until they were 70, and then we're simply told it's time for you to retire, you've got to go. So you'll have smoking gun cases where you have either the point blank statement that the person is old or too old or should retire, slow, new blood, etc. I bracket all of those in the smoking gun category because you have an explicit statement that the company wants to hire someone younger. That's a smoking gun. But there are also other viable and even strong age discrimination cases where, say, a person is working at a tech company and she's 65 years old and she is left off of big projects. She's not invited to important meetings. If folks go to a conference, she's the last one to get the invite, or she doesn't get the invite at all, right? She's not being given the same opportunities to contribute. She's not being given the same opportunities for growth, development, promotion, advancement within the company. I've seen plenty of age discrimination cases that involve that sort of fact pattern as well. Obviously, from a selection standpoint, the stronger the case, the better. So I'm really looking for cases that involve the smoking gun, that involve comments about a person being too old or slow or not having enough energy. We need some new ideas in here. We need to get some kids right out of college, because they've got all the cutting edge, this or that, right? Those are smoking gun cases. Those are obviously going to be stronger. But I will pursue cases where, an employee who's, 60 or 65 or 70 is basically being cut off of access to all of the other opportunities and sort of facets of the business and the job that would allow that employee to advance their career. Because the idea behind that way of thinking, the company way of thinking, is why would we put time and resources and money and rope this person in on these other projects, responsibilities, advancement opportunities, etc. Why would we rope them in if they're 65 and they're probably going to leave in short order? So we might as well just cut them off of that, relegate them to whatever they're doing and say, look, this person's kind of a finite resource. We're not going to get more out of them. That's how companies think about that. And companies, have even been caught red-handed, saying that in internal correspondence, emails, text messages, etc. So there are viable cases that don't involve the smoking gun, statement of discriminatory animus or motivation, but they clearly have a fact pattern that supports a discrimination claim where you have several other employees similarly situated who are given access to the resources, the advancement opportunities, the conferences, everything else, but you have older folks in the same position who are being deprived those opportunities. That is also a viable case. So that's number one. I'm either looking for the smoking gun or I'm looking for a clear pattern of that older employee being cut off or cut out of those other meaningful opportunities. I'm looking for one or two, okay? Beyond that, I'm also looking for strong documented history of favorable performance reviews. I'm not interested in messing with any of these cases where the person was either a mediocre employee or a marginal employee or had a history of negative performance reviews. Why? Well, because from a very sort of basic standpoint, in terms of litigation, the company we'll be able to point to that and say, we didn't fire Sarah because of her age, or we didn't deprive her of these opportunities because of her age. We fired her, or we didn't promote her, didn't include her in XYZ because her performance was already struggling. That is a legally viable argument. And more often than not, in that kind of fact pattern, the employer is going to prevail if there's a history of negative performance reviews. So I'm just not messing with that at this point in my career. I get hundreds of these. I can pick and choose the ones I want. And the ones I want have either smoking gun or a fact pattern depriving the person of opportunity, while younger folks get those opportunities. 2, favorable performance track record, the longer the better, okay? If you've been somewhere for 6 months, if you've been somewhere for 6 years, much different story and much stronger case from a factual standpoint. 3, I'm also looking for an adverse employment decision. I need something. Okay, it can't just be, I was treated differently, I didn't get invited to the break room for cupcakes, people weren't nice to me, I was bullied. I'm sorry, but I don't want to hear any of that nonsense. Why? Because that means nothing from an actual nuts and bolts legal litigation standpoint. You need an adverse employment decision. You need something that materially affected your job, whether that's outright termination, demotion, cutting your salary, cutting your hours, denying you a bonus you were entitled to, whatever it is, okay? There has to be something that is concrete, material, and adverse to your job situation. Those are the big 3 buckets that I'm looking for. So now that I've told you about what I see in terms of age discrimination, I'll give you a little further background on yours truly. Jonathan Pollard. I am the founder and principal of Pollard PLLC. When I started the firm 12 years ago or so, I was a solo practitioner. We had one office in Fort Lauderdale. I did everything from soup to nuts, including take cases to trial in federal court. Since then, we now have offices in Fort Lauderdale, Miami, St. Louis. There are 4 attorneys in the firm, and we have litigated, arbitrated, or mediated literally hundreds of employment cases. So if you have a case, or you think you might have a case involving employment discrimination, particularly if you're in Florida or Missouri, do not hesitate to reach out to our office. Jonathan Pollard, thanks for watching. Have a good day.